Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law Section. I'm Sergei Zaslavsky, and today's episode is Consumer Welfare the Right Policy for Antitrust Enforcement? Unpacking the Debate. Antitrust enforcers, academics, and politicians are embroiled in a debate over whether the consumer welfare standard is the right policy for antitrust enforcement in the United States. What are they fighting about, and why does it matter? In this episode, we talk to two prominent antitrust practitioners and leaders in the ABA Antitrust Law Section about this fascinating and important subject. My co-host today is Alicia Downey. What are we doing today, Alicia?
Oh, hi, Sergei. Today we have two special guests to talk about what the fight is all about regarding the consumer welfare standard. Our guests are Fiona Schaeffer and Ilana Kattan. Fiona is currently the vice chair of the Antitrust Law Section. She's also a partner in the New York office of Milbank, where her antitrust counseling and litigation practice is international in scope. Fiona began her legal career in the UK and has appeared before courts and regulators in the US, the EU, and countries all over the world. Ilana Kattan is a senior associate in the Washington, D.C. office of Freshfields. She is serving on the section's content committee as a vice chair and has been working with senior leadership, like Fiona, on the development of a series of interactive live stream debates on cutting-edge issues in the field of competition and consumer protection. As it happens, the first debate in that series is about the consumer welfare standard, the topic of today's episode. Fiona and Ilana, welcome to our Curious Amalgam.
Thank you, Alicia.
Thank you.
So, Fiona, let's start us off for listeners who are not antitrust experts or economists. What is the consumer welfare standard?
Well, fundamentally, Alicia, the consumer welfare standard is all about the goal of antitrust law being to protect competition and consumers, not individual competitors. It's associated with a treatise that was authored by Professor Bork in the 70s called The Antitrust Paradox, and a Chicago school of economists who focused very much on economic efficiency as the guiding tool for antitrust enforcement. The antitrust paradox that Bork highlighted was that antitrust enforcement in the 50s and 60s had actually artificially increased prices by protecting inefficient companies from competition. So there's a few things that are associated with the consumer welfare standard that are important to the debate today. First, consumer welfare advocates say big isn't necessarily bad. In fact, some say companies should aspire to become monopolies. That's the essence of free market competition. They also say that most mergers and business practices are benign and should be permitted. They trust economic analysis to determine which transactions and business practices should be challenged. And they say that aside from hardcore cartels, efforts among competitors to fix prices or rig bids or allocate markets, aside from that really nefarious conduct, the burden is on the party challenging a merger or business practice to prove that it's illegal. They reject presumptions of illegality because they're concerned that the potential harms from challenging mergers and conduct that may ultimately prove to be benign are higher than the risks of failing to challenge mergers or conduct that ultimately may harm consumers and competition.
All right, so the consumer welfare standard then is clearly a term of art within the field of competition and antitrust law here in the United States. Now, you've spoken about sort of what the underlying philosophy is for that standard, and we're here to talk about a current debate over whether that standard is the right policy for antitrust. Broadly speaking, what's the debate about?
Well, there are a number of debates, Alicia, but fundamentally, This is a debate over the goals of antitrust and whose interests antitrust laws are intended to protect. Critics of the consumer welfare standard say that the original purpose and the intent of antitrust laws is not just about protecting consumers, and it's not just about economic efficiency. They would say that when Standard Oil was brought, that case was brought against the Rockefellers and their accumulation of economic power in the oil industry, there was a concern that big is indeed bad, and that antitrust laws are designed not just to protect consumers from higher prices, lower output, or less innovation. They're also about preserving a democracy where there are many different types of competitors, where there isn't an accumulation of economic power in the few, and where economic equality is a goal and an outcome of antitrust enforcement.
Ilana, specifically, who is taking what position these days?
At a high level, there are three general positions, or camps, if you will, debating the consumer welfare standard today. The traditional approach, which is what we have in the courts today, is the consumer welfare standard. What is the impact of a given conduct or merger on consumers? Proponents of this traditional approach argue that this standard should remain the lodestar for antitrust enforcement. We then have a modern camp. For example, economist Carl Shapiro, who is a proponent of this approach, positions the modern camp as a middle ground between the traditional approach that we have in the courts and the Neo-Brandeis approach. The modern view is that the consumer welfare standard should remain the standard for antitrust enforcement. But proponents of the modern approach also think that antitrust enforcement has just become too lax, so they advocate for more aggressive enforcement of the antitrust laws under the consumer welfare standard. For example, they would impose rebuttable presumptions of illegality for certain conduct that would lower the burdens for plaintiffs to bring successful challenges. The final camp is the Neo-Brandeis approach. This is named after Justice Brandeis because of his concern with the harms of economic concentration, or the curse of bigness, as he wrote. You might have also heard this approach referred to as hipster antitrust. And this is the position held by the leaders of the U.S. antitrust agencies today. FTC Chairwoman Lina Khan and the head of the DOJ's antitrust division, Jonathan Kanter, are both prominent Neo-Brandeisians. Neo-Brandeisians believe that the consumer welfare standard, as Fiona mentioned, is just too narrow, and it's not the right standard for antitrust enforcement. They believe that lax antitrust enforcement has led to increasing economic concentration and thereby other social ills, such as rising income inequality. And they believe that this rising economic concentration poses a threat to the American democracy because it results in the concentration of political power. Under the Neo-Brandeisian approach, proponents would advocate for antitrust to return to its focus on the structure of markets, which they believe is more faithful to the legislative history of the antitrust laws, which they believe reflects Congress' concerns with issues beyond just the welfare of consumers, such as the preservation of open markets. How would the Neo-Brandeis approach, though, be implemented in practice? Well, there's a variety of proposals that we've seen raised in the media, but as a whole, Neo-Brandeisians tend to favor simple, bright-line rules for antitrust. We don't have an opportunity or time to talk about all of them, so I'm just going to name a few. For example, they would create presumptions that certain conduct is illegal, such as for exclusive dealing, refuses to deal, and below-cost pricing by dominant or near-dominant firms. Neo-Brandeisians would also challenge the possession of monopoly power itself under no-fault rules. In other words, even in the absence of anti-competitive, what we call exclusionary conduct. These are just a few of the ways that the Neo-Brandeisians would revise the framework for antitrust enforcement by shifting away from a consumer welfare standard.
Turning back to you, Fiona, why is this a topic of importance outside a group like the Antitrust Law Section of the American Bar Association? Is this a purely academic issue? Does this really matter in the real world?
Absolutely. Because the debate affects who is going to enforce the antitrust laws. As you heard from Ilana, we currently have two progressives as head of the major antitrust enforcement authorities in the US, the Federal Trade Commission and the Antitrust Division of the Department of Justice. It affects which cases they bring and how aggressively antitrust is enforced. And perhaps most fundamentally, it affects what laws they're going to be enforcing. You don't have to be an antitrust guru to read the papers every day today and see how many bills are being proposed on the Hill that attempt to rebalance antitrust enforcement in a variety of ways. For example, by lessening the burden for the government to challenge mergers, by making it more difficult for tech platforms to undertake mergers. Given the prominence of tech platforms in our lives and the focus of progressives on trying to rebalance their power, the fact that we're reading about this debate in our newspapers every day and that folks on the Hill are introducing legislation to change the consumer welfare standard and how antitrust is enforced, I think underscores that this debate is not at all academic. It's affecting our daily lives.
What do you think is driving the debate, and why is it coming to the forefront now?
I think it's partially the impact of living in a digital economy, the rise of tech giants, platforms that many people believe have delivered significant benefits to consumers, but other people, including small businesses, workers, small entrepreneurs, believe that tech platforms, on balance, have been harmful. And the critics of the consumer welfare standard say that it's just not up to the task of challenging conduct by tech platforms in the digital economy and should be replaced or at a minimum substantially revamped with more aggressive enforcement and better tools that the antitrust enforcers and private plaintiffs can bring and win more cases.
Are there any other factors that are contributing to this recent surge in calls to reevaluate antitrust enforcement?
I think that there is a recognition that the US economy is much more concentrated today than it was 50 years ago. And there's also an appreciation that economic inequality has increased. And many people are beginning to think that antitrust law here is a culprit, that it has not helped in the effort to prevent dominant companies from being the norm in our economy.
Is that a pretty accepted viewpoint, that the antitrust law enforcement is what's related to these economic outcomes? Or is there a lot of debate? Is this caused by antitrust law? Is this caused by other policies? How live is that issue?
I think it's very live, Sergei. Defenders of the consumer welfare standard point to the US economy and say, what do you mean this is not a good outcome? We have more innovation here than other parts of the world. The rise of tech platforms has been really beneficial for consumers and other stakeholders in the economy. If we were to have a more restrictive antitrust enforcement approach, not only would consumers be harmed, but the economy would be less vibrant, businesses would be less free to innovate, and that would harm all of us.
Now, turning back to you, Ilana, is the consumer welfare standard something unique to U.S. antitrust law? Are there similar debates going on in other jurisdictions? How are they manifested?
Yeah, it's a great question. I think that, focusing more on the second part to start, what is sort of this global movement that we have right now is this populist push that distrusts technology and big technology in particular. So we have this debate going on around the world whether the antitrust laws that various jurisdictions have, whether those are sufficient to address conduct in digital markets. So the U.S. is certainly not unique in having to grapple with questions of whether the antitrust laws are flexible enough to address digital markets, and if not, how do we address that and make them the most effective ways that we can? This is why we're seeing investigations and cases brought against tech companies around the world. And we're also seeing proposed legislation to address conduct specifically by these big tech companies, not just in the US, You might have heard the other day about the Klobuchar co-sponsored bill that just made its way through the Senate Judiciary Committee that would, prohibit effectively self-preferencing by large tech companies. But you're also seeing similar sentiments in the EU, such as the EU's Digital Markets Act, which would make companies or define companies as gatekeepers and then impose on them certain obligations of conduct. So you do see sort of this populist sentiment around the world and antitrust regimes having to confront whether their antitrust laws are up to the task.
Fiona, what is the role of the antitrust law section in the debate?
Well, we like to think that we're always in the center of the most important debates affecting antitrust policy and enforcement. Our membership, Alicia, is pretty diverse. And so we, as an association, I think, encompass proponents of the traditional consumer welfare standard, as well as critics of that standard, those who think antitrust enforcement has been too lax, and those who think that antitrust focusing on consumer welfare is just too narrow and the wrong standard. One of the ways in which we are working to understand the different positions on this debate and maybe, dare I say, even move towards some form of consensus is we are organizing what's called a hot tub debate. I love that concept. It comes from Australia. Not only do I love being warm and in hot tubs, but what the hot tub debate is it brings everyone on all sides of an issue into one panel, one debate. And instead of people speaking to each other in their echo chambers, speaking to the converted, as it were, we're actually trying to facilitate conversations across the various aisles here so that we're not just blindly defending the consumer welfare standard or just aggressively knocking it down. We're trying to better understand where are areas that antitrust law may have fallen down? What are the gaps? What are the holes? Why is it that more merger cases aren't brought and brought successfully? Why is it that more dominant companies are not able to be challenged for their conduct? And should dominant companies be challenged just for being dominant? These are the issues that we'll be debating in, I think, the first of its kind hot tub, bringing, as I said, players and participants from all sides of these debates into one room in a panel that it will be moderated by Bill Kovacic and available live and for generations to come. I'm really looking forward to that debate on February 10th at 12 noon.
We'll have links to the live stream on the webpage for this episode, which may or may not lead you to the on-demand version, but we'll be sure to make that available when it's finally done. So thank you both for being excellent guests. That was a very interesting topic. I think you've whetted our appetite about the consumer welfare standard. I'm going to turn it back over to Sergei, though, for some final segments. Take it away, Sergei.
All right, let's start with you, Fiona. Could you tell our listeners something interesting about yourself that people who only know you professionally might not know about you?
Well, Sergei, I'm not sure how interesting it is, but I confess my original aspiration as a young person and student was not to become an antitrust lawyer or even a lawyer at all. My goal was to become a rock star. And my second goal was to become a Wimbledon tennis champion. I guess, fortunately for the world, I did not seriously attempt either, but I maintain a strong interest in music and I love watching and playing tennis.
Well, being a rock star antitrust lawyer isn't a bad consolation prize. So that is pretty interesting. And Ilana, same question for you. And, you've had a minute to think about it, unlike Fiona, so we expect our answer to be extra interesting.
I guess I will share this story that is easily findable online or Googleable. When I was 6 years old, I was at a Hanukkah party at the White House, and I accidentally lit my hair on fire, and President Clinton put it out. And it turned into an entire international incident because the newspapers in Israel, for example, were saying American president saves Israeli girl. And then in the U.S., it kind of the same thing about, became a huge thing about how the president saved a little child with my singed hair. So that's a big story. I actually ended up getting to go on The Tonight Show as a guest. So that was pretty cool.
Wow. I've got to ask, how did you manage to set your hair on fire, and where were your parents when this was happening?
So there were no parents there. It was part of an Jewish after-school program that got invited. And mind you, I'm in a hot pink Ninja Turtles t-shirt, black leggings, and white sneakers to meet the president. And I just got a little bit bored, I think, when people were singing, or I was tired. And so I leaned back against the desk, and my ponytail dipped into the flame. And I just happened to have been standing right next to President Clinton, so he put it out with his hands.
You said it was a Hanukkah party. Was it the menorah, like a menorah on flame? Oh, my goodness.
Yes, exactly.
Many biblical images are conjured.
So Fiona wanted to be famous by being a rock star, and you actually got to be famous by lighting your hair on fire.
Yes, inadvertently, yes.
All right. Well, now it's time for our last segment, The Curious Hat.
And now it's time for The Curious Hat.
It's a segment that we have on every show, and the way this works is you each pick a number between 1 and 25, and there's a question associated with that number. So let's start with you first, Ilana. Pick a number between 1 and 25.
7.
All right.
I was going to pick that number, Ilana.
Mind melt right there.
Okay, Ilana, what was your first job?
I was a camp counselor, actually. But before that, I mean, if we're counting volunteer work, I volunteered at Georgetown Hospital for a summer and worked in a ward helping the patients, and then also worked at the front desk directing patients around the hospital. So if anybody ever needs directions around Georgetown Hospital, I got you.
I think that job used to be called being a candy striper. Is that what you were called?
Yeah, I wasn't called a candy striper, and they definitely didn't make us wear outfits, but I think that's effectively what it was.
Was this like a summer job when you were in high school?
Yeah, I thought I wanted to be a doctor for a while, and then I realized I can't stand the sight of blood, so.
Yeah, well, that would be an issue for being a doctor. So lawyer, some would say a better choice, but, it depends on how aggressive the litigation is.
And I have to tell you about my first job. I know that Ilana got number 7, but my first job is a job that I wish was like military service. Everyone had to do it. And that job was washing dishes in a staff cafeteria in a department store. And I would start on Friday nights, and I would go throughout the weekend. And of course, the people who were the dishwashers during the work week, the regular week, Monday to Friday, would leave me all of the biggest and baddest dishes to wash. It taught me a lot. It taught me humility. It taught me that, we all need to pull together to get stuff done, even if that stuff is dirty and not particularly attractive. And it's something that I've tried to pass on, my dishwashing skills, to my kids. So I was hugely proud when I was able to get my son a dishwashing job this summer. He could join the elite dishwashing family that is the Schaeffers.
Certainly important lesson not to leave the really bad dishes for others. I think that's certainly has resonance in every workplace. Well, that's it for this week's episode of our Curious Amalgam. Thank you for joining us.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.